Of our management, on behalf of our chairman and vice chairman and other members of the management, and on behalf of our faculty, I wholeheartedly welcome Mr. S. Thangapandian, Deputy Controller of Patents and Designs, Chennai Patent Office, Ministry of Commerce. And last year, we had an interaction with him. He gave a seminar for us. It was an eye-opener for us. And really, we did well last year, and the number of patents have been published. And this year, the awareness among the faculty related to patents is very high. So during this time, we thought that if SAR comes again and they refresh again to all our faculty members, definitely our faculty knowledge, they will get enriched, and definitely we can do more. We can step in further. So for that purpose only, this workshop has been organized by Institution Innovation Council and the IPR coordinator, Dr. Srinivasan. And on this occasion, I congratulate IIC and Dr. Srinivasan for having organized such a wonderful function. And once again, hearty welcome to Mr. Thangapandian sir and all the members here. I wish all the
National Intellectual Property Policy. So with that, the development of IPR in the country has taken a very good leap, especially in terms of, as I mentioned, in terms of the infrastructure development and in terms of capacity building of the officials of patent office, and in terms of awareness creation among the stakeholders. So let us take this. I would always like to stop me wherever you feel it is not, you have some queries on that particular slide, or you have general queries. You can always stop me and shoot your queries. Yeah. I think the admin can mute my video, so it will be much better. Yeah, I can do that. Thank you. So some basics, maybe people present in the meeting would have attended so many IPR seminars, but though it is a repetition, it's always better for people who have not got an opportunity to attend such seminars. So I would like to repeat certain slides as a introduction to the new people, as well as to the people who have already undergone the subject, as a refreshment. So basically, when we talk about property, we will only think about the tangible form of properties, which we all know. The touch and feel properties are called tangible form of properties. But there is another category of property which is intangible, which is intellectual property. This property is the one which is the result of our intellectual mind, which emanates from the intellectual ideas. So whatever thing that we develop using our intellectual knowledge, intellectual input, that gives the intellectual property. So I'm going to just display a picture wherein you will be able to know what are all the intellectual properties. I'm not talking about the rights, but what are all the intellectual properties that is possible in a product. Okay, because IP and product goes along, separate. Okay, so with this one product, you can see different types of intellectual properties. Okay, and the rights that is given by the government to the property owners. First thing is patent, which is about the constructional feature of the device, technical feature of the device, and the method by which the device is operated comes under the patents. Design registration is about casing the aesthetic look of the cover, I would say rather, or the case in which the electronic circuitry is incorporated, the aesthetic look of the device. Trademark is about the brand name of the device, and copyright is, of course, the instruction manual comes along with the device. So no device, no article goes without an intellectual property into it. So basically, all these four forms are very much important when we talk in terms of manufacturing or a business. So all these forms of intellectual property and their rights are very important. These are the, except the trade secrets, all other forms of intellectual properties displayed here. Am I audible, sir? Hello?
Yes, sir. Audible, sir.
Yes, sir.
Audible, sir. Audible, sir.
So all other forms of intellectual property rights have
Now not audible, sir. Sir?
the professional people, and to give a deep insight into the patents and its procedure. Okay. Let me start with the first trademarks. Trademarks, as we all know, it is nothing but the brand name of a product. I'm just displaying certain pictures with which I'm sure you'll be able to identify the product or the service associated with the logos. Okay. Yeah, this is the earlier slide is about it is only either an image or a word associated with the product, whereas in this slide you can see the image or an brand name associated with captions as well. So both the forms can be registered as trademarks. Only main requirement for a word to qualify itself as a trademark is it should be distinguished from the goods. It should not exactly match, or it should not exactly convey the type of good that is the trademark is representing. Okay, it can be in the form of word, logos, pictures, or a combination of any of this. For a word or a term to qualify as a trademark, the basic requirement as the Trademark Act is it should be distinctive in the sense it should be a unique coined word, and that word should already registered, but should not mislead the customers. So it may not be best, but if you give a caption "my quality is best," then it misleads the consumers. So it should be distinctive and not deceptive. Okay? Or it should not take its the base of the coining of the word should not take its base from some other word. Okay, so it should be distinctive and not deceptive. This is the basic requirement for a word to qualify itself as a trademark. This is one good example which we usually show the evolution of trademark. Xerox is one actually a company, a brand name. It is not an English word. It is not a general dictionary word, but now it has become a part of the dictionary. This is a very common word. We tend to use this word very frequently whenever we wanted to take a photocopy. We never use the technical word of getting a photocopy. We only say we wanted a Xerox copy. So this is the evolution. This is one example for a case study wherein how the trademark maybe lead to a litigation. Okay. Now we come to copyrights. Copyrights is one of the intellectual property. In order to the copyright right is given by the government to the creator of the intellectual work. Okay, this is basically the pictures itself is very clear. It's saying that basically copyright is given for any sculpture work or any artistic work. It can be given for any literary work. You can say a book displayed there. The copyright can be given for any musical performances or musical work. It can be for any cinematographic work, or more importantly, the copyright is applicable for softwares. Okay, software. When I talk about software, it is only about the coding part. It is only about the literary work of the coding part. It is actually considered to be a literary work under copyrights, software programming. It is nowhere connected. It is only about the expressions of the software. It is not about the ideas behind the or the logic behind the software programming. It is only the programming, the literary work as such can be protected under copyrights. The emergence of copyright, the first Indian law is 1857. Copyright, as I mentioned, protects the expressions and not ideas. Okay, copyright, either it be an artistic work or a literary or a musical work, it is only about the expressions and not the ideas. It is copyright is always an exclusive right granted to the owner for literary, artistic, or scientific work. Privileges given to the owner is to use or authorize others to use. Others can obtain license from the owner. The others means the interested people can obtain the license for reproduction, public performance, translation, or adaptation. Okay. Basically, when I talk about scientific work, all the literary scientific work, it is written in the form of a book, or it is written in the form of a project thesis work, or it is in the form of a paper which can be published in a technical journal. Let it be even you during your college admissions, you are preparing a prospectus for your college. Even that can be protected under copyrights. In addition to that, even lab manuals, the notes, whatever the teachers will be preparing, all those things, literary works can be covered as defined as scientific work under the copyrights. What can be protected under copyrights? You can protect to obtain a right on the intellectual property. The foremost requirement for protection of right is it should be an original work. Let it be trademark or copyrights or design registration or patents or whatever it may be. First requirement is it should be an original work. Okay. Here again, copyright, it should be original work. It can be in the form of writings, music, or sculptures. Boldly, I've shown three important type of work which can be protected under copyrights: technical drawings, computer programs, multimedia protections. In fact, the translations also can be covered under copyrights: paintings, lectures, choreographic works, maps, and cinematographic works. But they may fall under different classification under copyrights. Okay, because copyrights covers 4 or 5 type of works that can be protected under copyrights protection. One is, as I mentioned, literary work. Any type of writing comes under literary work. Even computer programs comes under literary work. Similarly, artistic work, it can be in the form of a drawing, painting, even maps also can be an artistic work. Okay. So such artistic works, whatever the things that comes under the definition of artistic work, can be protected under copyrights. And music performance. It can be a music performance, can be music composition. It can be a lyrics comes under literary work, but music composition written in the music language comes under copyright. The stage performance with the music, if you add a video and you wanted to project it, that also can be protected under copyrights. This we have seen a painting or a sculpture, drawing, engraving, photograph, any such work comes under artistic. Work of architecture, in fact, and artistic craftsmanship. This is a definition in the Copyright Act. Related rights. Okay, so copyrights, we are talking about copyrights. Who can take a copyright on his work is a person who has applied his intellectual mind to create an artistic, literary, or any type of musical work, music composition, becomes eligible to be the owner of copyrights. He can take a copyright in his name. But there are certain related rights, because one work, if supposing a musical composition is coming out, cinematographic music in the form of a song is coming out, because it cannot be a work of a single person. So it requires a music composer to do the music. It requires a lyricist to write the lyrics, and it requires a cinematographer to make a motion picture out of it. Okay. So all these people, they are involved in creation of a one intellectual work. That is a song, maybe a cinema song. Okay. So when the related rights are given to the people who are adding to the intellectual work. These are called neighboring rights. Okay. Who can get persons or organizations who would add substantial creative, technical, or organizational skill to bring the work to public. So they can get the neighboring rights. For example, composer, music composer who creates a music work. Okay, so he is the original owner, because without the basic music, we cannot come out with a song. Then somebody there should perform the music. The performing artist who gives the voice for the music and recordings. So there needs somebody to invest money in creation of all these things. So they are called producers of recordings and broadcasting organization. Somebody has to take the work to the public. Okay. So that particular organization who invest money in taking the work to the public through some medium, they are also can also enjoy the related rights. So what are all not infringements? So all along we have been talking about rights. Okay, so rights give some monopoly right for a person who has created the intellectual work. Okay. When he enjoys the monopoly right, in the sense he is preventing others from using it. So if what happens if somebody uses it, they can use it, but provided with the approval of the person who is holding the right. But if they use the work without taking the approval of the person, then it becomes an infringement. Okay. Under copyrights, certain aspects, certain things, if it is done without the permission of the copyright holder, they are not considered to be infringement. Okay. So if the work is used for some research study, and if the work, if, say for example, the music composition has been taken as an item for criticism. Somebody criticizes the music composition using the portion of the music composition, then it cannot be taken as an infringement. Reporting certain events in the news reporters, whatever news events they are creating. Okay, actually the news events have taken place and somebody is reporting on the events. Such type of work is not infringement. If the work is used for some judicial purpose to establish the evidence, as an evidence it is being used, then it is not considered to be an infringement. Performance to a non-paying audience. If supposing cinematography work or a musical, you are not able to, if you are not gaining anything out of the performance, then such performance is not an infringement. Otherwise, all other forms of copying work becomes an infringement. Term of copyright is 60 years normally. For any literary work, 60 years starts from the day when the author, the life of author ends. Okay. Otherwise, in general, we can take it as the term of copyright as 60 years from the date of publication of the work by the government. Okay. Where we can, where to apply for copyrights? As far as copyright is earlier, sometime back, I think some 4 or 5 years back, the copyright was under Minister of Education, but now it has been attached to the Ministry of Commerce and Industry, and the office is located in Delhi. Whatever applications we need to send, we have to send directly to Copyright Office, and they do the further processing for registration. Basic requirement for filing a copyright application is you need to fill a application form for applying for copyright. Along with the application form, you need to attach the work, at least 2 copies of the work, what you have done. If it is a book, then you have to attach the book. If it is any musical performance, then the appropriate performance in a memory device, in the CD form or any other memory device should be attached along with your application. Recently, also they have made a provision for online applications. You need not send it physically, but online applications you can fill in, and there is a provision for filing the application as well as uploading your work. Though there is a memory restriction for uploading your work, but the process of application has been simplified now. You can do it online, prepare your literary work, and if you fill in the forms, application forms for copyright, and when you are uploading along with the your application forms, you can upload your work also. Okay, so you need not send it physically, and minimum fees is there, prescribed fees, government fees is there that you have to pay. The process is very, very simple. Once the application is received and they scrutinize whether it is an original work, and they go about registration of the copyrights. So next we move on to industrial designs. Industrial designs of much importance too, as far as small and medium enterprises are concerned. Industrial design is basically, it is not about the functionality, it is not about the advantage of the design, it is only the aesthetic look of the product. So though it may be technically superior when compared to the already existing products, and if it is to be filed under designs, if it is to be covered under design registration, the office only looks for the aesthetic aspect of the design. They don't get into the technical aspects. It is only the aesthetic aspect. In the first instance, if you are producing a design product, what is appealing to the eye is only counted here. Okay, nothing about the technical aspects. Okay. I have displayed some 3 photographs. One is about the car seat, another is a chair, and a footwear. Okay. You just look into the items, products from the point of view of aesthetics of the product. Okay, functionality, that is different, but aesthetics only is counted under design registration. Mostly SMEs, small medium enterprises, they create a lot of design variations in the already existing products. Mostly the design variations can be in the form of size, dimensions, color, or even some designs that may be incorporated in the product. Okay. Basically, to attract the consumers, functionality may be the same, but basically to attract the consumers to buy the product. Okay. So as I told you, it is only about the ornamental or aesthetic aspect of an article. It can be a variation can be created as a 2-dimensional or 3-dimensional feature. Criteria for registration, again, it should, the foremost requirement, it should be original work and it should be industrially reproducible. The design registration, it's once it is done, then it is valid for 15 years. Again, you could see the citrus juicer or the CFL type of bulbs that has been displayed here, nowhere to do with the functionality of it. It was only the design of it. Okay. Again, design registration office is located in Kolkata. Only one office for our country. Whatever the applications you are going to send, you need to send it to Kolkata office. But one advantage is there. patent office is also receiving the design applications, and we will forward it to the Kolkata office. But only application receipts is done in regional office, but all other processing of the application is done in Kolkata office. Again, design registration is a very simple process. The application forms are available in the net. You need to fill in an application form. Along with the application form, you have to attach the photographs or neatly drawn drawings of the product on various views. It can be a top view, side view, front view, isometric view. So whatever possible view that can better display the aesthetic look of the product, you need to attach along with the application form. Okay. So this is the basic requirement, and once it is sent, if you are supposing you are in Chennai region, you are going to file an application for design. Patent office will receive the application. We will issue a receipt for the fees we collected, and we will be forwarding the application to Kolkata office for further processing. All reports, design registration certificate, everything will be issued from the Kolkata office directly. Okay. Again, there is a possibility of online application as far as designs are concerned. Very simplified process is there. Once you register it, along with you have a digital certificate, digital signature with you, you can very well go about filing design applications. Geographic indications. Yeah. So we have seen trademarks, copyrights, design registration. Now it is geographical indications. Geographical indications are nothing but any product or process which takes its value, uniqueness from the region from where it is tested. Okay. So such products or such process can be registered under geographical indications registration. The picture itself very clearly will indicate what are the unique products, the uniqueness in the product, and the topic of geographical indications is very well known across the country now. Each and every state of the country, they are trying to identify the traditionally practiced methods or traditionally made products which is unique to their own state. Okay, so they are trying to register it under geographical indications, because the registration under geographical indications not only gives opinion to the opinion to the consumers, opinion to the outside world that our country has got so and such huge traditionally followed methods or traditionally manufactured products. So the Tanjore doll is there, Nagpur oranges. The oranges takes its flavor and juice from the region from where it is grown. Okay, because of the climatic conditions of the region. Again, Darjeeling tea is again unique because of the area where it is cultivated. Kanjivaram sarees, again, it's a unique method of weaving that is followed in Kanjivaram, and Tanjore painting, in fact. So, geographical indications of goods. The feature of the good is attributable to its origin. Attributable to its origin. As I have already mentioned, a registration gives an assurance of quality and distinctiveness. So the government has devised a logo, especially now people might have heard about silk mark. Okay, similar to that, government have now came out with a logo for geographical indications. So whatever products that are registered under geographical indications will carry the logo. Once it is taken to the market and the logo is present there, it will have very good value. Yeah. Now we come to the topic of patents.
Black coffee.
Yeah. Patents. Patents. It is the legislation of patent is not new. It is as old as 1856. It was not given as a patent right. It was given as an exclusive privilege at that point of time. Later, due to evolution and a lot of developments, later date, it has been it is started giving legislation has been reformed, and we started giving as patent rights. Okay. Nothing but it's a monopoly right to the patentee by the government. Okay. the government gives the monopoly right to the patent owner or the intellectual property owner for the full disclosure of his technology or know-how to the government. The validity of patent rights is 20 years. Once you acquire a patent, once you file for a patent, from the date of filing of patent application, okay, 20 years you can enjoy the monopoly rights. What are all the rights? See, I have been talking about monopoly. So under monopoly, what are all the rights we can enjoy? That I will tell you. Okay. One more important point is the patent is a territorial right. It is not a universal right. Okay. Once you apply for a patent in India and you take a patent certificate, patent rights, that right you can execute the right, prosecute the right only within the territory of India. You cannot go and practice your patent right which you have taken from India in some other country. If you want a patent right in other countries, then you need to apply a separate patent application in the respective country and take the patent rights from the country. Okay. So two things. One is it is valid for 20 years from the date of filing the application for patent. Secondly, it is a territorial right. Okay, so people have been thinking patents will be patented. No, it is not like that. Simplicity is no bar. Okay, we don't go into the complexity. We don't only appreciate the complex nature of inventions. It is not like that. The simplicity is no bar. How simple let it be the innovation. If it qualifies the patent test, then it can get very well the patent certificate. So to bring out that particular point, I have displayed a safety pin which has got a very basic scientific principle behind it, as well as a satellite communication system. So any branch of science and technology, let it be a simplest product with a very basic science built into it, or let it be a very complex system involving too many technological innovations into it. They both are can be qualified as a innovation, and patent applications can be filed for this. Not only restricted to any, because you see patent, normally as engineers, when we think about patents, we only think about devices. Mostly we tend to don't think about other fields, because other fields, even agricultural field also, a lot of innovations are coming out. Pharmaceuticals, we receive patent applications from pharmacy companies, drug companies, mechanical related companies, and electrical electronics, biotechnology related inventions are there, civil engineering related inventions are there. So we receive applications from varied fields. It is not restricted to one single field. So patent eligibility. Okay. So we have seen inventions, simplicity is no bar, but there is a test under Patent Act for a device or a method to become patent eligible or to qualify as an invention. Basically, three criteria to be satisfied. One is novelty, inventiveness, and industrial applicability. Novelty. When we talk about novelty, the original work, again, it should be a original intellectual work. Inventiveness. Inventiveness is how the patent office assess the inventiveness is in comparison with the previous art. Supposing you take a you come out with an innovation in a mobile device. Okay, there are mobile devices existing. So what office normally does, we will only go through the document, whatever you have filed, try to find out, understand what is the invention is about, and to assess the inventiveness, we will go to the database and check for similar type of citations, similar type of technical documents, which we may have the technology displayed there. So we will compare your innovation, your document, your evidence with the previously available documents and try to find out whether your innovation has got inventiveness. Okay. So inventiveness is always in comparison with the already existing prior art. Similarly, novelty also. Novelty, one-to-one exact match should be there. If there is an already existing prior art which exactly matches your Exactly means point to point. It matches your innovation or invention, what you have produced in your document. Then the office will say you don't have a novelty. Otherwise, if there is a slight difference also, then we accord the novelty, but we go about for the second test of finding out the inventiveness. Okay. And industrial applicability. Industrial applicability, your product or method should be capable to be manufactured in industry or applied in the industry. These are the three basic criteria by which your invention is qualified for patent. Okay. So novelty is assessed only with the database. First, once you file a patent application, we will give the application number and the date and time of filing the application. So whatever documents, whatever technical literature that is available prior to your date of filing or published, that is available in the public domain prior to your date of filing, if such citations, prior art documents or technical literatures that are published prior to your date of patent application filing, if those documents are having something or similar to your innovation displayed in those documents, then they will spoil your novelty. Okay. So it is an assessment. We go back and see before your date of filing the patent application, what are all the documents that may have your type of innovation. This is how we assess the novelty. Okay. There is one exception because this I wanted to stress here, because being academicians working in the colleges, we tend to make a lot of innovations, but our innovations, we always normally think about the presentation before a learned society in an exhibition, or as a paper presentation we do it, or a technical publication we do it. Such type of technical display in an exhibition, such type of paper presentation or your topic presentation before a learned society, or publication in a technical journal as a part of your academic requirement, we normally take away your novelty. Okay. But in Patent Act, there is an exception given. Even though you have already displayed, even though you have taken your technology to the public domain, you have an option of filing a patent application within a year's time. Within 1 year of such publication elsewhere, you are able to file a patent application with Patent Office. We normally consider novelty of the particular work. Okay. We don't deny novelty, but it becomes your responsibility of proving that you have come to Patent Office within 12 months. Inventiveness, I told you, it is only about technical advancement or economic significance over the already existing technology. Okay. Industrial applicability we have seen. Okay, there are certain restrictions. Okay. Though your invention qualify to be pass all the three tests of novelty, inventiveness, and industrial applicability, there are certain other restrictions in Patent Act which apply. We will apply and find out whether your invention qualifies even that. If your invention, though it is accorded the status of invention, if your invention does not pass the test under this subject matter, then it is quite difficult to give a patent. Okay. These restrictions are brought into the Patent Act basically to protect the interest of public as well as interest of the country. Okay. Certain restrictions are given in the Section 3 of the Patent Act and Section 4. That we will see one by one. Quickly, Section 3A, it talks about any innovation or invention which is frivolous or which anything obviously contrary to well-established natural laws. If anything, any device or any method which is frivolous or is based on any contrary to natural law, well-established natural law. Example is perpetual motion machines. Such type of innovations is not sustainable. Okay, so they are not patent eligible. 3B talks about any invention which its primary or intended use is contrary to public order or morality. Okay, and causes serious prejudice to human, animal, or plant life. Okay, so such type of inventions falls under Section 3B. Example I have given: any device, apparatus, or machine for theft, doing a robbery, or committing and injuring human beings. method of adulteration of food. Such type of device or a method which is contrary, which may create confusion among public order, definitely patents will not be given. 3C, it's a mere discovery of a scientific principle. Patents, they don't become eligible for a patent, because I'm not saying that scientific principle, discovering a scientific principle itself, it's not an intellectual work. It is an intellectual work, but such intellectual work does not qualify to get a patent under the present Patents Act. Okay, but if you come out with a scientific principle and you are able to apply the scientific principle to develop a product or to develop a methodology, such type of product or a method is for patent eligible. Mere discovery of a scientific principle alone is not eligible. 3D, this is one very good section, mostly applied for pharmaceutical type of inventions. Okay. The mere discovery of a new form of a known substance, not patent eligible. Mere discovery of any new property or new use of a known substance. Already a substance is known. Okay, for the substance is being used for some other purpose. If the same substance it is used now, something has come out in your mind and you are trying to find out a different use of the already known substance, and you wanted to file a patent application, you cannot establish an intellectual work because you have only discovered a new use for a already known substance. Okay, nothing intellectual. It may be accidentally you might have come across a new use for a known substance. Such type of work does not qualify to apply for a patent. Okay. Example is an aspirin, which is a cardiovascular disease, used for cardiovascular disease. Earlier, it was used as an analgesic drug. Now, somebody has identified that it can also be used for cardiovascular ailments. Similarly, there was a example, Novartis drug case example was there, wherein they came out with an anti-cancer drug. It was filed, patent application has been filed for the particular drug, anti-cancer drug, and our Chennai office, patent office only examined the case, and we given a report saying that this particular application for drug does not prove the efficacy of the drug. It is only a mere structural change. The structure of the molecule alone is changed, and there is no proven, there is no unique efficacy is brought out because of the mere structural change. So mere discover of a new form. So we objected the application under mere discover of a new form, and the patent has been rejected. It has got into a lot of litigations with the High Court of Honorable High Court of Chennai, and it has gone up to the Honorable Supreme Court. But even there, patent office decision has been upheld. Section 3E, a substance obtained by a mere admixture resulting only in the aggregation of the properties. Okay, it's only a mere admixture. 2 or 3 compounds you are combining together, and there is no combined synergistic effect. It is only an aggregation, joining of compounds, but independently they will do their own performance. Such type of mere admixture does not qualify to become patent, to get a patent. 3F, mere arrangement or rearrangement or duplication of known devices. See, we know from the reading through the statement itself, we will come to know what is the maximum intellectual work that has been thought of in making the device. A mere arrangement or rearrangement. See, say for example, you see the device, it has got a small fan, a torch attached there, a bulb is also attached. They are all powered by single battery. Other than that, there is no system, there is no mechanism that makes them work in tandem. Okay, they are going to function independently. Once suitable on-off switch are used, the fan will rotate separately and torchlight may glow and the bulb also may glow separately. But there is no functionality of the device in tandem. The different components of the device, they don't function in tandem. They are going to function independently. It is only a mere clubbing of known devices. So the intellectual input that has gone into creation of the device is not sufficient enough to qualify this product for patent. Section 3H, method of agricultural article. Naturally, we cannot patent any agricultural or horticultural method. Okay. Section 3I. 3I is about any process or method for medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or treatment of human being, or any process for treatment of animals, because we cannot patent and give monopoly right for such type of process, because it's a life process requirement. Such process cannot be patented. Okay, but I'm talking about only the method or a process that cannot be patented, but the device, biomedical devices that are being utilized for any treatment, for any diagnostics, for any curative work, definitely those biomedical devices, if they qualify the test of patent, then they become eligible to be patented. Only the process is not patentable under this section 3I. Section 3J, plant and animals in whole or any part thereof. Again, we cannot go about give a patent for a plant or an animal. Okay. But microorganisms, genetically modified microorganisms, developed microorganisms, yes, can be patented. Section 3K, more relevant to engineers. Any mathematical method, business method, or a computer program per se or algorithms cannot be patented. The meaning is any mathematical method, any mathematical model. See, it is what I'm talking purely about the method or a model. Okay, which is only going to display only the mathematics behind it. I'm not talking about the model. If it is employed in an engineering, developing an engineering product or developing an engineering method, a lot of mathematical models are being utilized as a part of the development. I'm talking about only the mathematics. I'm not talking about the mathematics being used to develop a technology product. Okay, so the method which involves only mathematics, not patentable. Similarly, any business method which may involve any transaction of money or goods, not patentable. And a computer program per se means I'm talking about computer program coding, the computer program, the literary work behind the computer program. I'm not talking about the logic or technology behind the computer program or the function that is going to execute when it is run in a computer system. I'm not talking about that. I'm only talking about the computer program per se or algorithms per se. Okay. So such work are covered under copyrights and they don't qualify to become patent eligible under Patents Act. Section 3L copyrights, so they don't qualify under patent. Topography of integrated circuits, again separate. There is a separate system of protection is there. Layout of integrated circuits protection registration is there, and it is covered under that statute, and it is not covered under patents. Section 3M, it's a mere scheme or rule or method of performing mental act or method of playing game. So such type of method which don't execute any technical strategies into it, then such methods are not patentable. Section 3N, it's about presentation of information, not patentable. 3P, it's an invention which is based on traditional knowledge. See, over generations, our people, over generations, they have been practicing certain methods, or they have been developing certain products or compositions that are practiced over generations, but those are termed to be traditional knowledge of our country. Such traditional knowledge of our country, we don't give patents. There is a separate traditional knowledge digital library is there. Whenever we come across such applications which is purely based on traditional knowledge, we make an assessment of particular invention using the digital library. If it falls under the items that is already covered under digital library, then we don't give patent for such applications. Mostly it is applicable, the traditional knowledge type of restriction is applicable for any already practiced Siddha composition or Ayurveda composition or any other form of medicine that is practiced over generations. and it has formed part of the digital library. So we have completed section 3, wherein we have seen the certain restrictions in the Patent Act, though your innovation qualify to become qualify as an invention, but they don't become patent eligible because of the restrictions. Okay. So these things we need to have an idea. It is not enough that we know only the definition of patents. We should also be aware of what is patentable and what is not patentable, so that we don't, whenever we think about doing a project, whenever we think about doing a topic, take a topic for creating an innovation, then when we are clear about what is patentable and what is not patentable, then we don't involve ourselves in such a thing which will not lead to an ultimate goal of getting a patent. Okay. Section 4, again there is a restriction: any invention related to atomic energy not patentable. Okay. So any invention which has involved atomic energy materials as given in the Atomic Energy Act, such inventions we don't give patent. Then defense related inventions: any invention which is very useful for defense purpose, okay, not patentable. But basically when I talk about atomic energy and the defense related inventions, what I'm trying to say is when we receive such applications, we make a preliminary assessment whether it is atomic related or defense related. Once we conclude that it is atomic or defense related, we refer such applications to the respective departments. We refer the application related to defense ministry, so that if the ministry says no, it is not prejudicial to the defense of the country, then we take up the application and process it. We don't reject it straight away. Similarly, when it is an atomic energy related invention, then we refer the matter to the Department of Atomic Energy for their clearance. Once they clear, we go about carrying out the patent examination on that. We don't straight away reject it. Okay, these are two requirements in the Patent Act. One is working of patents in India. Okay, what I have to do after getting a patent in India? Okay. Basic idea is to get a patent and commercialize it. When we are commercializing, the mandatory requirement under Patent Act, once a patent has been registered, from the date of registration, every year you need to file a form giving the details about working of patents in India. Okay, this is basically the ultimate goal of giving a monopoly should reach the public of India. So the government expects whatever innovations that has been registered as patent are being manufactured, are being practiced in the territory of India, so that ultimately the people are benefited. Second thing is about compulsory license. Compulsory license in the COVID situation, we have been hearing this term compulsory license. The courts are talking about compulsory license, and so many other institutions are also talking about compulsory license. This is one provision in the Patent Act by which the government can have control over certain aspects of the invention. Okay. One example is Natco Pharma versus Bayer. Bayer has come out with an invention. It's a pharmaceutical composition called Nexavar, anti-cancer drug again. But when it has been patented and it has been given in the market, I understood that the particular medicine, it's of high-priced medicine. So normally it may not be feasible for any middle-class people or any people who are ill and they are not affordable to buy it. So in such a situation, a company, Natco Pharma, it's a generic drug manufacturer. They expressed their interest of manufacturing the particular same composition with at least cost. So the government has taken a view of it, and applications were filed by Natco Pharma for taking a compulsory license from Bayer. So our department has taken the application and they have examined it. There are certain criteria to be fulfilled by the license, the person who is seeking the license, and there are certain conditions to be met, or there are certain conditions to be satisfied. That particular patent has not been properly executed or has not been properly reaching to the public of India. In that case, the office has taken a decision to give a compulsory license to the Natco Pharma. Similarly, there are certain other compulsory license also issued, provided if they satisfy such applications satisfied all the requirements of giving a compulsory license. What to do basically? What to do? We may be confused. See, what to do if you invent? The first thing what you have to do if you come out with an idea, innovative idea or invention, is to do not publish it anywhere. See, I have told you, even though you publish it, you can come back to patent office within 12 months and file. That is publication before a learned society as a part of your academic requirement. In general, if you ask any suggestion, we will always suggest even such display of your technology before a learned society. You don't do it before filing a patent application. Okay. So first and foremost thing, if you make up your mind to go for a patent, then first and foremost thing, after you come out with an idea, you have to file a patent application. So get patent and commercialize it. Okay. Yeah. Filing a patent application. Who can file a patent application? Anybody can file a patent application. Individuals, single individual or individuals jointly also can file. The inventors can file. Here I would like to clarify the definition of inventor, applicant, and patent agent. Inventor is the person from whom the innovation comes out, who's actually involved in doing the innovation. Applicant is the person who is filing a patent application. Okay. Say for example, any organization, an employee is working in an organization in an R&D division and he is coming out with an innovation. Okay, that particular person is an inventor. Okay, and he has done the innovation on behalf of the company. When they are going to file a patent application, say for example, the application is filed in the name of the company. Okay, then company becomes the patent owner. Though the inventor has done the R&D work to come out with an invention, when the application is filed in the name of the person, that such person becomes the patent owner. So there should be an agreement between the inventor and the applicant before they decide to file a patent application. But here, inventor themselves can be an applicant also. Inventor, once he come out with an invention, he can go straight away and in his own name, he can file a patent application. He can mention himself as an inventor as well as he can mention himself as a patent applicant. That is also possible. But when it is a relation between an employee and a company, then when the company wanted to file a patent application in the company name, then company becomes the patent owner. And the person who has done the invention will become the inventor. Jointly also you can do. When you are filing a patent application, along with the company name, you can also add your inventor name and file jointly also. That is also possible, allowed. Who is a patent agent? Patent agent is a person who is going to help out the inventor or an applicant to file a patent application for a consultation fees. They are qualified people registered with the patent office. Their list is available in the website. They pass the examination what the department conducts, and they qualify themselves as patent agent. But we don't recommend any patent agent to support any applicant. Okay, it is the duty of the applicant to find out a suitable agent for them. Office only conducts the examination and register persons who have qualified the examination as patent agents. Okay. Where to file? We've got 4 patent office across the country: Chennai, Mumbai, Kolkata, Delhi. Based on the jurisdiction, the application has to be filed. These are different types of applications: ordinary, convention, PCT, patent of addition, and divisional applications. We will only deal with the ordinary application for better understanding. Convention application, I'm just going to give you one line explanation. It is only, it comes under Paris Convention. Okay, there is a international convention arrangement where many countries are member of the convention. Once you file a patent application in India, okay, today, and you are finding out a very good market, okay, in some other very good market in some other country, say for example Singapore, okay, and you wanted to file, you cannot patent in and execute in Singapore. You need to separately take a patent in Singapore. Okay, for that case, if you go to Singapore and apply for a patent, Singapore being member of the Paris Convention, they will give the same date of which you take. Yeah, This is the advantage filing a patent application under convention. Okay. Basic requirement for convention application is once you file a patent application in India and you wanted to file it abroad, within 12 months, you have to do that filing in other countries. Otherwise, you will not get the date. You will not get the priority. This is the one requirement. Okay. PCT application, the third PCT application. It's almost similar to convention application. But PCT is Patent Cooperation Treaty. Again, under the treaty, so many countries are member of the treaty internationally. And once you file a patent application in India, okay, and you want to say, for example, you file a PCT application in India. Okay, PCT application, it's called an international application. Once you file an application in India, the advantage is you will get 31 months time to file a patent application separately in other countries abroad. 31 months time, and not 12 months. The time is 31 months. In comparison to convention application, PCT application gives you 31 months to file a patent application abroad. Then PCT application also, once filed, it will give you a search report within 6 months of your filing. With the search report, there will be an assessment of novelty, inventiveness, patentability, everything will be there. You can go through the search report and come to a conclusion whether your invention is worth proceeding further, because you are going to pay the fees, PCT fees, which is going to be in US dollars. Quite a lump sum amount you are going to pay. You have to decide whether you need to proceed with the application, applying in other countries or not. That decision you can take based on the search report that is given by the PCT application. So 31 months time you are getting, search report you are getting within 6 months. These are, and your priority date also will be protected. These are the advantages of PCT application. Patent of addition is nothing. Once you file an application today and later date, if you come out with any further developments on the same invention, then you can file a patent of addition along with your original application. Similarly, divisional application. Any patent application to be filed for one invention only. By mistake, if you have clubbed certain inventions and file a single application, then there is an option of dividing the patent applications without losing the date of filing. Okay, because as far as any IP is concerned, the date of filing is more important. If first you file, you get the advantage. Date is important. First to file the application gets the advantage. Date of filing the application is we call it as a priority date. Okay, so basic documents that is required for filing a patent application. As usual, application forms will be there. Along with the application forms, you need to pay prescribed fees. The most important document in the patent documentation is specification, which is nothing but description of the invention. We are talking about provisional and complete specification. Provisional, to simplify, I would say it is a temporary specification. Once you conceive an idea of an innovation, but you have not fully developed it, but you are sure that the idea, this subject matter, you can take it forward and you can come out with a completely developed product or a completely developed method. Okay. In that case, without losing time, you can come to office and immediately file an application along with provisional specification, so that your date and time are secure. You get the priority. And after filing the provisional specification, you will get 12 months time to complete your project and come out with the final description of your invention, which you can file it as a complete specification. Okay. Fees for filing is only when you are filing a provisional application. As usual, the normal fees you have to pay. But when you are coming to complete specification after 12 months, you don't require to pay any fees. If the specification does not exceed certain number of pages or does not add more content, then you need not pay any extra fees. Okay, fees whatever you have paid at the time of filing provisional holds good. Okay. So advantages of provisional filing, I told you get priority for invention. You will get 12 months time to develop and complete your contents of application. Here I wanted to the people present to have a close look at the topics displayed here, because going through the topics, you will all easily come to conclusion that these topics are nothing but topic you are using in your project thesis. Okay. So drafting a specification for patent purpose is not difficult at all. It is very, very easy. It carries the it actually carries the contents of claims. Content of claims. Claims
Santoshini madam, please mute your mic. Santoshini madam, please mute your mic.
Any specification has two parts. One is description under the topics we have seen in the previous slide. Another portion is claims. Okay. So under claims, what is a claim? Claims are nothing, are just a statement of your invention which fix legal boundary of your invention. Okay. So this you have it, and we'll see an example of claim so that it will be much clearer to you. This is one example of claim. It is for a mobile phone which has got certain constructional features. You can see a mobile communication terminal. They are not specifically mentioning it as a mobile phone. They're using the general terminology, technical term as communication terminal. Okay. It has got a main housing, fold cover, hinge. Fold cover contains a display screen, and the main housing contains a keypad. This is the invention. So this is how a claim has to be written. It is nothing but a statement of your invention, incorporating all the inventive features of your invention to fix a legal boundary for your patent. So when, suppose for example, when your application, after getting a patent, if somebody files a litigation against your patent in the court, okay, the court will take only the claims, what has been given in the claims, as the and it will accord the rights, patent rights, only to the items that has been given in the covered under the claims. So as patent office, what we say is, description you can elaborately give how your invention, how you came to the innovation, what is there in the prior art, what is the problem you are solving from the prior art, and how the solution works, how the device works. All those things you can cover in the description. When you're coming to claims, you have to draft claims in such a way you are incorporating all the features of your invention into the claims without losing even single point, such that it has a broad scope as well as covers all the features of your invention. Because the claims are going to be legally valid. More than the description, the claims will be legally considered. Okay. So basically, these are the documents required for filing a patent application. Form 1, Form 2, Form 3, the basic documents. Form 1 is application form. Form 2 is the form along with the specification. Form 3, Form 5, Form 18, and Form 9. Form 9 is request for early publication. Normally, your application once filed, today you are going to file a patent application. We will publish your patent application within 18 months time in our official journal. This is a process. Okay. Supposing you have already you have filed a provisional and you have completed, and finally complete specification will proceed for publication within 18 months. Somebody comes with the invention which is already complete and they wanted to file a complete specification directly. And they say that, yeah, we have done our invention, complete specification is ready, we are not going for provisional. In the first instance itself, we wanted to file a complete specification because invention is already done and we wanted to file a specification. We cannot wait till 18 months time publication, because all the process of patent examination takes place after publication. Okay. Once it is published in our official journal, then only your application will be allotted for examination. So after 18 months, it will be published. Thereafter, it will be taken up for examination. So if somebody don't have time to wait till 18 months, we wanted to commercialize it, we have done all the things, we cannot wait till 18 months. Then there is an option available. If you file a Form 9, which is a request for early publication, today you are filing an application along with Form 9, a complete specification. If it is filed, then your application will be published in your official journal within a month's time. Okay, once within a month's time it is published, that 18 months time is shrinking to 1 month now. Within 1 month it will be published, and after publication, thereafter all other process will start. The advantage of publication is publication gives you all the rights of a patent holder except one right, which is a right to file a case against an infringer. Okay, somebody copies, then you wanted to file a case against them. You can do it only you get a patent certificate in hand, which you will get after all examination process is completed. But all other rights, like rights to give a license, rights to give an assignment, rights to sell, okay, rights to enter into business contract, everything you can enjoy the right once your application is published. So it is always better, once you file an application, wait till publication, till you take up your project to the outside world. Once it is published, then you will get all the rights of patent holder. So it is much better, instead of waiting for 18 months, you can always use the option of getting it months time. So basically, the patent process involves certain stages. First is filing a patent application. Okay, with the provisional specification you are filing. So office will take the documents and keep it under confidential record. We will not publish it. If it is a provisional, we will not publish it. We will wait till you file a complete specification. You get 12 months time to file a complete specification. Okay. Supposing you have filed a complete specification, 12 months time. Before that also you can file it. Within 12 months you can file it. Once complete specification is filed, then office starts the functions. Your application will proceed for publication within another 6 months, 18 months, I told you, from the date of filing. So 6 months it will be published. Once published, next process is examination. Your application, once published, it will be allotted to an expert panel. The experts based on field of the invention. There are pharmaceutical experts are there, the biotechnology people are there, electrical engineers are there, mechanical engineers are there. Based on the subject of the application will be allotted to a team of people for examination. Examination is nothing, it's a process making an assessment of whether your invention passed the patent test, like novelty, inventiveness, industrial applicability, whether your invention passed the section 3 test, patent eligible test, okay, whether your invention is related to atomic energy or defense, whether your invention that has been described, given in the description, is completely described, okay, properly described, the language is easily understandable. All those assessment we make it, we give a report. As a part of examination, we give a report. That report is called first examination report, in short FER. Okay, when such reports are coming to you, it is your duty now as an applicant, it is your duty to now to go through the report, study the objections that has been raised by the office, and give your reply, point by point reply to the objections raised, and submit the reply to patent office. What happens after the reply? We are receiving the reply. Your reply will be taken up and it will be again examined. If the reply is convincing and if it satisfies all the objections raised in the first examination report, office will proceed for patent grant. If the reply is not convincing, what happens? We don't straight away reject it. We give one more opportunity under natural justice, under the provisions of the Act, to the applicant by giving a hearing notice. Hearing notice, again, any pending objections are there, will be communicated to the applicant in the form of a hearing notice. Again, it's a report with a hearing option. Hearing means as you appear in the court to explain yourself, similarly you can appear before us at the time fixed in physically also or through video conferencing. All video conferencing links will be provided. Through video conferencing you appear and explain your case. When the particular expert is asking you certain doubts, you can clarify the doubts and satisfy the objections. So once that is done, after the hearing, then the expert will take a decision whether to grant or refuse the application. So each and every stage, opportunities are given for the applicant without straight away rejecting the opportunities. Fair opportunity will be given at each stage. So the process is filing, publication, examination, final decision whether grant or refusal. So filing, once publication takes place 18 months. If you wanted to shorten the period, 1 month early publication request to get filed. After publication, you have to file a request for examination. Then only it will be examined under Form 18, 1/8. You have to file. Once it is filed, then examination process will start. Allotting the application to an expert team. They will examine and they will give a report. There are certain timelines also. Based on there may be some administrative delay, but not too much of delay nowadays. It is quickly being processed now. So examination will take place. Reports will be sent. A report you have to reply back. For replying back, once report has reached you, for replying back, you will get 6 months time. Okay, which you can extend for another 3 more months. So altogether 9 months time you'll have, but you can immediately reply. The next day also you can file your reply. There is no restriction on that. Once reply is received, then again processing, hearing, again grant or refusal decision will be given. Here, say for example, you have filed an application today and you with the provisional specification, and 12 months is expired and you are not filing a complete specification. What happens? Office will understand that you have lost interest in filing the complete specification. So it amounts to withdrawing the application. So we will not take any action on the provisional application. It will be just lying there. Without complete specification, we will not take any action on that. So if you miss the timeline of 12 months, then there is no remedy. Similarly, when it comes to after you receive a patent report, examination report, you have 6 months which can be extended by 3 more months by paying additional fees. Say for example 9 months. If you don't reply anything within the 9 months and the last date is already over, what happens? Office will treat your application. You have taken a decision to abandon, be automatically abandoned. So it becomes very necessary for each applicant to keep a watch of the timelines. Whether your application is filed within time, what is this current status? What is the current status of application? If it is missing, if this time is approaching, you need to take fast action to file the replies. Okay, there is a facility you can send emails. There is a facility provided in our website to dynamically watch the status of the applications. It gives the status under which condition your application, under which process your application is going through. That is there available in the website. The provision is there. You can check the status. Okay. All the documents, whatever you are filing, are also uploaded in the. Once it is published, it will be uploaded in the website. Okay. So this is the basic idea. This is old, actually, this is an old format, but the format has changed now. There's a patent certificate. Just for example, I'm showing you, which will have patent number, application number, data filing, which is reference. So after getting a patent, what I have to do? The actual basic requirement of getting a patent is to commercialize it. Is there any official requirement, government requirements after getting a patent? Yes. Government requirement is there to keep the patent in force till 20 years. You have to pay renewal fees. Okay. So starting from 3rd year onwards, because the 20-year term starts from the date of filing, not from the date of giving patent to you. From the date of filing the application, patent period starts. So 3 years, 3rd year onwards, once patent has been issued, the calculation will be done starting from the date of application filing. 2 years will be free of cost, and 3rd year onwards you have to pay renewal fees, which is very minimum case of individuals. For 20 years term, you have to pay the renewal fees to keep it in force. This is the requirement. And again, we have already discussed working of patent statement should be filed with the office every year. That is the 2 requirements. Okay. PCT, I have already told you what are the advantages of PCT. This is website interface for our website, first page interface. There you can see comprehensive e-filing facilities there, meaning all the documents can be filed online. We are not processing any papers. Papers, when it is received by post, yes, we do process, but mostly now applications are being filed. 90% of the applications are being filed only through online. Okay. Once you have a digital signature, You can file it, file all your applications, pay fees. Documents without fees also can be filed online, sitting at your home. You need not, of course, you are welcome to visit the office, but you need not be physically present to file an application. All acknowledgements, receipts will be generated automatically and will be emailed to you. Okay. Similarly, as an office, it's a completely paperless office, and we are working on cloud. Okay. So all the offices are connected. Once we receive an application, distribution of application take place across the country, and it will be examined across the different offices, and reports will be issued through emails. So it is always necessary. Active email IDs are provided, and emails are being continuously watched for any communication from the office. Public search facility is also given. This public search facility is a Indian patent database wherein you can search for published as well as granted patents. So this is a search interface of our database. Okay, to provide you some idea, this is an interface of European Patent Office search facility. It's a free facility. You can make use of this also to search the worldwide documents. Patent scope is WIPO patent database. You can also use this. It's a free database. You can use through the search through this database. After patent, I told you these are the rights you get for manufacturing, selling, licensing, assigning, cross licensing, improve with further R&D, or protect with patent abolition and ahead. Okay. So as I told you, publication is very important after filing the patent application. Once publication is taking place, after publication, you can enjoy the rights and you can take the initiatives for commercialization. Finally, IP is intellectual property and is also an intellectual profit. Okay, because IP, creation of IP involves investment of time, investment of energy, okay, investment of knowledge, of course, investment of money. Okay. As a result of all this investment, we are coming out with an intellectual property, okay, which has to be legally protected. So you have to identify the intellectual property, what you have generated, and protect it under appropriate legislation. It can be a trademark, it can be a copyright, it can be a geographic indication, it can be a design, or it can be a patent, it can be a layout of an integrated circuit, it can be a plant variety, whatever it may be. So you need to have knowledge of all the forms of rights, so that you select the most appropriate right for your own intellectual property and you protect it legally. The basic idea of protection is to give a legal validity to that. While executing the monopoly right, you may have some hindrances from outside world. In order to come out with from all the hindrances and be commercially successful, it is necessary that intellectual property is protected properly, okay, under the legislation. So your IP is not only intellectual property, it is also an intellectual profit to you. Just we always conclude our discussion with this projection of this device. In the beginning, I have shown you a mobile phone. Now it is a pressure cooker. The basic idea is to change the mindset of people and to inculcate the intellectual ideas into the mind, so that whenever they come across any innovative product, or at least any product for that matter, any product or any method, wherever they come across, they should always have an intellectual eye to look at the product in terms of the properties that has been with which the particular device or method is made. Okay. So you are try to identify the intellectual property rights that has been protected for the particular product. Okay. This is the request. With the request, I conclude my session. I welcome the queries. I'll be happy to answer all your queries. Thank you. Thank you. I know there will be a lot of queries because this is the second session. So it